leading up to from the point that Miss Guyger entered the apartment. She had walked into her apartment and there was an intruder inside her apartment under section 9.32A and Broughton, as I laid out in my brief, she would have been entitled to use deadly force in self-defense. Okay.
Well, you cite the Broughton case, but if you read the Broughton case, the defendant or the appellant in that case was mistaken about some facts, but not mistaken in fact. Mistaken about some of the facts related to the self-defense claim. The defendant in that case testified that he thought the about to be decedent was reaching into a motorcycle side bag for a weapon and shot him, and the jury rejected that self-defense claim, which seems awfully similar to the jury's rejection of your client's self-defense claim here.
Your Honor, the self-defense, again, but the problem with what happened in Broughton is that the self-defense claim there was different than the self-defense claim here. My client, according to the facts, had a reasonable apprehension of danger when she walked into what she thought was her apartment. Now, again, if we agree that she thought she walked into her apartment, then the mistake of fact instruction applies. And then the question is, was her belief, was her apprehension of the danger reasonable? Now, the case law is very clear that I set forth in my brief and the reply brief that, she doesn't have to be in actual danger, only apparent danger. Was that apparent danger reasonable? Okay. Now, the evidence presented during the trial showed that many other people inadvertently walked to the wrong floor of the Southside Flat Apartments. They walked to the wrong, or they drove to the wrong level of the garage of the Southside Flats Apartments. They walked to the wrong door. One witness who, this wasn't like some man off the street. This witness was an attorney here in Dallas that works for a civil firm. He testified that one time he walked into the wrong apartment and didn't realize he was in the wrong apartment until he saw a lady sitting on the couch looking at him with amazement. So again, the issue is, if the court believes that her mistaken fact in going to apartment 1478, which is one floor above hers, the same side, same part of the building, was reasonable, then the mistake of fact instruction applies.
Mr. Mola, Mr. Mola, would you address the case cited by the state in their brief, Solis v. State, a Texas Court of Criminal Appeals case, which is our precedent, with talking about the when you're entitled to that instruction on mistake of fact, that the kind of culpability is meant culpable mental state, which in this case is the intent to kill. In other words, there has to be evidence negating the intent to kill. Would you address our precedent in the Solis v. State case?
1 second here.
416 Southwest 3rd, 419, Texas Court of Criminal Appeals, 2013.
Yes, Your Honor. Your Honor, the issue is, as discussed in Solis, that there is other precedent that I address that I think is more applicable in this case. But in discussing Solis, there was an intent to kill on Miss Guyger's part. She testified to it. Okay. The problem is, I think for the state's argument is that, again, if she had been in her own apartment, does the court believe that she would have had justification to shoot to kill? Okay. This is not a case, of where she emptied her magazine. There was a lot of stuff in the media about that. She fired 2 shots after she said, "Let me see your hands," twice. She walked in, she saw a dark shadow in the back. There was very little lighting. She said, "Let me see your hands, let me see your hands," twice. Joshua Brown testified, the witness that lived across the hallway, that he heard loud voices of 2 people that sounded surprised to see each other. Okay. So again, yes, she intended to pull the trigger. Yes, she intended to kill who she thought was an intruder in her home. Now, I'm not understating the fact that these facts have never happened before in Texas. Okay. There's never been a situation where a person that I know of in Texas walked into the wrong home, reasonably or unreasonably, and shot someone inside the home. That's never happened in Texas. So I acknowledge that she intended to kill because that's what she testified. The question is, and her getting to that point, when she walked into the wrong apartment because of the perfect storm, as Ranger Armstrong described, going to the wrong floor, walking down the wrong hall, coming to the wrong door, missing the clues of the vase that should have been there, missing the clue of the half moon red floor mat, missing the clue of the fact that, she was at apartment 1478, not 1378, which was the sign that was way up to her left. If she missed all those clues, was her entering the apartment believing that it was hers a reasonable set of facts that would allow application of section 8.02A? And I think that's a question for the court. And again, I acknowledge that she intended to kill. That's, I never stated in my brief that she didn't intend to kill. But the fact of the matter is, if she had picked up on any of those clues, however minor, despite the fact that many other people in the apartment building missed those clues when they were walking, although I acknowledge that, they didn't shoot anyone inside the apartment, understand that, she was a police officer. Okay. And, there's a police officer that testified during the trial that when you come upon a scene like she did, if it was a burglary call, then you would cover and conceal and wait for backup. But that same officer testified that if he had come upon his own home and he thought there was an intruder inside, he would go inside and go after the intruder. Okay, now,
Mr. Mola, aren't you erroneously mixing mistake of fact, defense, and self-defense justification? Those are in under two different titles in our Texas Penal Code. Mistake of fact is a defense and self-defense is a justification. So doesn't the fact that she testified that she believed she was in her own apartment just go to whether or not she had a reasonable belief that she was in such immediate danger that she had to use deadly force? In other words, go to self-defense. So aren't you mixing those two?
Your Honor, I'm not mixing the two because I think the only way that what happened would make sense if you apply section 8.02A to what happened. 8.02A on its face, it's a defense to prosecution that the actor through mistake formed a reasonable belief about a matter of fact if her mistaken belief negated the kind of culpability required for commission of the offense. Okay, she was convicted of intentionally or knowingly killing another human. Okay, intentionally or knowingly killing another human is an evil act. Okay, that's what she was convicted of. The problem is that when she entered what she thought was her own apartment, she did not have evil intent when she entered her own apartment. Merely, again.
Just because of her alleged mistaken belief about where she was doesn't negate her intent to kill.
But Your Honor, it negates, my argument is it negates the mens rea, it negates the evil intent. Okay, because we wouldn't be here talking about this if she had walked into her own apartment. Okay, so she walks into her own apartment and she shoots and kills an intruder. Okay, here she walked into the wrong apartment, and in these horrific set of facts, she shot and killed Mr. Jean. The only difference between those two scenarios is her mistaken belief about where she was. Was that mistaken belief reasonable under the circumstances? Okay, now there are many, many cases from the Court of Criminal Appeals that say that mental culpability has to be inferred from the circumstances under which an act based on a defendant's words, acts, and conduct. Okay, I don't think you can reasonably, or anyone can reasonably state that when you consider all the facts of the case, when you consider what happened, okay, that she had an evil intent when she walked into what she thought was her own apartment.
Mr. Mulla, you're nearing the end of your time, and I know we need to get to your second issue concerning the lesser included criminally negligent homicide.
Yes, Your Honor.
Why do you think that you are entitled to that?
Your Honor, a criminal negligent homicide under section 19.05 of the Texas Penal Code and section 6.03D talks about inattentive risk creation or the failure to perceive a risk. Okay. As I explained in my brief in detail, I believe that Ms. Guyger at most is guilty of criminally negligent homicide because the evidence shows beyond a reasonable doubt, if the court were inclined to go this route, that she shot Mr. Jean, causing his death. That's undisputed. That she should have been aware that there was substantial unjustifiable risk of death from her conduct because she did not pay close attention or close enough attention to her surroundings and missed the clues of the vase, the red doormat, and the apartment number being off one digit. And the third is,
excuse me, Mr. Mulla, what evidence do we have in our record that shows that if she is guilty, she is only guilty of the lesser included criminally negligent homicide?
Well, Your Honor, in my brief, I went through 47 or 48 factual points, 48 distinct factual points. I start on page 82 of my brief and go through page 99, pointing that what occurred was a clear mistake of fact, and she acted reasonably under the circumstances. Look, Your Honor, she missed basically 4 clues about where she was. Okay, if the question is, she should have been more attentive, and that was some of the state's argument during closing, that she should have been paying better attention to where she was. Okay, so that constitutes a failure to perceive the risk of her actions. That's why I believe that criminally negligent homicide is a viable option for the court as a lesser included offense. She should have been paying more attention. The bottom line is she was convicted of walking into the wrong apartment and killing the occupant of that apartment.
Thank you, Mr. Mulla.
Thank you.
All right, if you mute yourself, please, there, Mr. Mulla. And Mr. Gladden, you have 20 minutes and you may begin when you're ready, sir.
Thank you. May it please the court. My name is Doug Gladden and I represent the state of Texas. This is a murder case, not a criminal trespass case. When Amber Guyger shot Botham Jean, she didn't take someone else's property. She took the life of a human being. She took Allison and Bertram's son. She took Brant and Alyssa's brother. She took Alexis Stossel's friend. She took Joshua Brown's neighbor. She didn't make a mistake about that. She knew Botham was a living human being. She pointed a gun at him. She intended to kill him. That's murder. It's not negligent. It's not mistake of fact. It's not justified. Amber Guyger murdered Botham Jean. This court should say so and affirm the trial court's judgment. Now, this appeal is about the sufficiency of the evidence, so we have to look at the standard of review. And the standard of review is that evidence is legally sufficient when viewed in the light most favorable to the verdict. Any rational trier of fact could find all of the essential elements of the offense beyond a reasonable doubt, and could find against the defendant on any defensive issue beyond a reasonable doubt. Now, that standard matters here for two reasons. First, this court has to decide what defensive issues were raised by the evidence in the first place. And then the question is not whether the jury could find for appellant on a defensive issue, it's whether any rational jury could find against her. So starting with the first, mistake of fact was not raised by the evidence in this case. Now, in the briefing and here in argument, appellant says that this case is about mistake of fact, but it's not. Mistake of fact is different from other defensive issues. Most defenses say, yes, I committed the offense, but it was justified, or it was necessary, or I was under duress. Mistake of fact is different. It says, I didn't commit the offense because due to a mistaken belief, I did not have the culpable mental state. Now, culpable mental states are intent, knowledge, recklessness, or criminal negligence, and they have to apply to the result of the conduct, the nature of the conduct, or the circumstances surrounding the conduct. For murder, the mental state relates to the result of the conduct. That is, you have to intend to cause death or serious bodily injury. Now, appellant is saying that her mistaken belief related to her reasonable belief that deadly force was necessary, but reasonable belief is not a culpable mental state. It's a term that's used in the penal code as a part of defensive issues and affirmative defenses. Specifically, in this case, self-defense requires you to have a reasonable belief that deadly force was immediately necessary. That's not a culpable mental state. It's simply a defensive issue. There was no evidence in this case of any mistaken belief on appellant's part that would negate her intent to kill Botham Jean. She never testified that she believed Botham was an animal, like a bear or a dog. She didn't testify that she believed her gun was unloaded or that she had a taser instead of a gun. She didn't believe the apartment was empty or that Botham was wearing body armor or that she was shooting blanks or that she was aiming away from Botham. All she said was that she believed she was in her own apartment, and that doesn't negate her intent to kill. So this court has to decide whether mistake of fact was raised by the evidence in this case. This court has the responsibility to apply the correct law and do so correctly. Now, this is the state's cross issue, and we're not asking for an advisory opinion on this. Whether mistake of fact was raised by the evidence in this case is a legal question, and the state will benefit from it here because the question on the appeal is whether the legal sufficiency analysis should look at the mistake of fact defense at all. Now, in the reply brief, appellant says this court has no jurisdiction on this because under Saghelm-Mabel, the state is asking this court to review an alleged jury charge error to provide guidance and prevent errors in the future. No. In Saghelm-Mabel, the instruction was on an evidentiary issue, specifically whether the defendant's statement was voluntary. That's not an element of the offense, and it's not a defensive issue. And the appellant in that case didn't raise anything related to the instruction on appeal. Here, appellant is challenging the sufficiency of the evidence, and she's arguing mistake of fact. Whether mistake of fact was raised by the evidence then is what this appeal is all about. Now, appellant says that the court can deal with this issue simply by deciding whether the jury erred in finding against her on her defensive issue. But this court can't deal with the issue that way. To do that, this court would have to say that mistake of fact was a defensive issue that was part of the hypothetically correct jury charge. But mistake of fact wasn't raised by the evidence. Since it wasn't raised by the evidence, this court cannot write an opinion that both sets out a hypothetically correct mistake of fact instruction and correctly applies the law in this case. This court would be left doing what the trial court did, which is applying the wrong law and doing so badly, and saying that if the appellant reasonably believed that she was in her own apartment, then the jury would have had to acquit her, even if the jury found that she committed murder and that it wasn't justified. And that's not the law. So that leaves self-defense as the only defensive issue raised by the evidence. And the standard of review matters for that, because the question is whether any jury could have rejected appellant's self-defense claim. The only evidence of self-defense in this case came from appellant's testimony. She said that she believed Botham was in her apartment, that she commanded him to show his hands and he didn't, and that he quickly moved toward her while saying, "Hey, hey." But the jury can disbelieve any or all of a witness's testimony. And if the jury didn't believe appellant's testimony, then there's no other evidence of self-defense, much less insufficient to reject self-defense. And all the other evidence in the case contradicted appellant's testimony. No one heard her give commands to show hands. Botham didn't have pockets where he could have hidden his hands. The trajectory of the gunshot wound means that he wasn't quickly moving toward her. And no reasonable person would have mistaken Botham's apartment with the red doormat, the backlit room number, the flashing red light on the lock, and the marijuana smell as her own. So then there are the elements of the offense that the state had to prove beyond a reasonable doubt. That appellant intentionally caused the death of an individual. Appellant admitted that she was the shooter, and the bullet in Botham's body came from her gun. She intentionally did it. She admitted that she intended to kill Botham. She shot center mass. She shot him with a firearm, which is a deadly weapon. She shot at a downward angle, and she didn't render first aid. She caused his death. He died of a gunshot wound. The gunshot came from his gun. And Botham was an individual. His sister testified that he was a human being who was alive. She spoke to him that same day, and he was excited about eating ice cream. The evidence in this case is sufficient to prove the elements of murder and to reject appellant's self-defense claim, and mistake of fact was not raised by the evidence in this case. I would ask that this court affirm the judgment of conviction. Does the court have any questions?
Do you have any, I'll have to go back and reread your brief, but was there any particular cases that you cited to, assuming the court wants to sustain your cross issue, anything in particular that you wanted the court to address, or any precedent that you think is most appropriate to apply?
The most appropriate precedent to apply is, I believe it's pronounced Pfeiffer v. State, that says this court can appropriately address a cross issue if the state would benefit from it on the resolution of the appeal. And the reason why the state benefits here is that this court has to decide whether mistake of fact was even part of the hypothetically correct jury charge that this court is going to analyze the sufficiency of the evidence on.
I guess what I'm kind of asking is, Mr. Mola mentioned in his argument that he couldn't find any particular case kind of on point factually. Are there any cases that you, like the Broughton case that he cited in his reply brief, I thought was actually on point for you, Mr. Gladden, or for the state. Are there any other cases that talk about mistake of fact not being appropriate? A mistake of fact regarding the reasonableness of the use of force, but not a legal mistake in fact.
Yes, Chief Justice Burns. I'm sorry, I misunderstood your question. There's a line of cases that talk about that. Broughton is the primary one. We have the lower court opinion that specifically says that a mistaken claim raises self-defense rather than mistake of fact. In the supplemental letter brief that I submitted to the court, there's two additional cases. One is from the 14th Court of Appeals, Rocha v. State, and then the other is from the Fort Worth Court of Appeals, Maupin v. State. And both of those cases recognize the same thing, that a person who claims that a mistaken belief about the reasonableness of their conduct is not a mistake of fact when you're talking about a result-oriented offense. It simply raises a defensive issue, whether you're talking about self-defense or defensive property. And then I guess what you would call the big case that supports all of this intellectually as an underpinning doctrine is Shaw. Because Shaw makes it very clear that when you're talking about a justification defense, like self-defense, Shaw was talking about, I believe, necessity, but either one, you're talking about necessity, justification, or self-defense, deadly force and self-defense, defense of property. Those are justifications under Chapter 9. And Chapter 9 says that it's a defense to prosecution that the conduct was justified. And what Shaw points out is that conduct means an act and the culpable mental state. So if you're claiming a mistaken belief that negates the culpable mental state, you don't have criminal conduct to justify under Chapter 9. And that's why, as Justice Myers said earlier, these are in different chapters of the Penal Code. These are separate defensive issues, and you can't shoehorn mistake of fact into a justification claim.
Thank you.
Mr. Glenn, I have just one comment.
Yes.
Thank you very much for an excellent written brief. It was very pleasing on the eye. As a matter of fact, I had my attorney look up what font you used because I liked it so much during late nights. That's appreciated. So thank you very much for the written brief and the letter brief, the letter as well.
You're welcome. And thank you, Justice Partita Kipnis.
All right, any other questions or? All right. Well, thank you, Mr. Gladden. Oh, sorry.
Thank you.
Thank you. All right, Mr. Mola, come on back. There you go, sir. All right. And Mr. Mola, you have 5 minutes for rebuttal and you may begin. Mr. Mola, I think you're still muted.
Can you hear me?
Yes, sir. Gotcha.
I have nothing further, Your Honor.
Okay. All right, then. Oops. Now I'm having there we go. Now I'm having a technical problem here. All right, then. I guess we're done then, and I thank both sides for excellent briefs and an excellent presentation today. We will be in recess in this matter, and we'll take the case under advisement, and we will issue our opinion in due course. The case is submitted. Thank you. We're in recess.
Thank you both very much.
Thank you both for excellent arguments. Thank you.
Okay, so that actually went pretty fast. I knew it wasn't going to last very long, but it actually went a little faster than I thought. I think what struck me was that Mr. Mola got a lot of questions and was interrupted very quickly. I believe it was by Judge Myers. He questioned pretty thoroughly about whether or not they were mixing defenses and justifications and that sort of thing, whereas Mr. Gladden was allowed to speak until he was done. What do you make of what we just saw here?
Well, Tanya, having gone through this process many times, we refer to it in the practice as having a hot panel versus having a cold panel. There are times when you think your position is going to prevail and you want a cold panel because it's just so obvious you're going to prevail. There are other times when you want a hot panel because you think it's an interesting issue and you want to know that the court shares your interest in it. As I pointed out before the argument started, you can't always take the tone and tenor of the questions as indicating how the court's going to rule or how a particular judge is going to rule. But if I were the prosecutor, I would walk out feeling very comfortable after this argument.
Somebody is asking about this whole mistake of fact issue. Am I correct in understanding that the state is arguing that mistake of fact shouldn't even have been part of the jury charge?
That is precisely what the state is arguing. And the way they have gone about it is just indicative of what a good lawyer Mr. Gladden is, because on a sufficiency review, the appeals court is supposed to come up with what would be the hypothetically correct jury charge. And what that means is you have all this case law from the past where some things that got put into the charge shouldn't have been there, something that made the state have to prove something they shouldn't have had to prove. And when it went up on appeal, the courts would say, well, no, we measure it by that charge that was actually given. And then years ago, the Court of Criminal Appeals finally said, no, when it comes to sufficiency, you're supposed to consider what the correct, hypothetically correct jury charge would be, and then you measure the evidence by that. And so since Mr. Mola from Ms. Guyger is arguing legal sufficiency, that puts into play what would the hypothetically correct jury charge be. And so Mr. Gladden is arguing, hey, it shouldn't have had mistake of fact. And the reason it shouldn't have had it is mistake of fact, under the case law cited by Mr. Gladden, is supposed to go to negating that intent to commit the crime. So with Officer Guyger's situation, her admitting, yes, I meant to shoot and kill, and that's obviously what happened, it didn't negate that. It was, I thought I was shooting to protect myself in my own apartment. So as those examples I talked about before the argument started, shooting into a car you truly believed was empty, it might be other crimes, is not necessarily murder, because that fact that you were mistaken about could negate your intent to kill.
So who do you believe is right? Mr. Gladden or Mr. Mola? Is mistake of fact a reasonable justification in this case?
Not under the law as it exists.
Okay. And that was interesting because, these are really complicated parts of the law, right? I don't think I'd ever really dealt with this whole concept of mistake of fact prior to the Amber Guyger trial. And one of the things that Mola said was basically if the justices believed that she believed she'd walked into her own apartment, then mistake of fact applies. And then you have to decide if her actions after that were reasonable. What you're saying is mistake of fact doesn't apply and shouldn't have even been part of the jury charge.
Well, and I can understand why the trial court did it, because you basically immunize the case from a claim on appeal that, oh, the charge should have been given. Well, if the charge got given, then there's no error in the trial courts having refused to give it. And a lot of times trial courts will do that. They'll be like, okay, maybe this is close, maybe it's not exactly applicable, but I'm going to give you that. And
kind of like a mulligan? Like a mulligan, kind of? Like a mulligan?
Not so much a mulligan. It's more that, okay, defense, maybe under the law you're not exactly entitled to that, but this is pretty close, so I'm going to give it to you, knowing full well that if you kept it out and you should have given it, that might get the case reversed on appeal.
Okay, so in a way, it makes sense from that perspective for the judge to have included it. Just, okay, guys, y'all want to make that argument? But it was pretty clear in watching this trial that the jury, because we actually, at Channel 8, we actually interviewed a couple of the jurors. They believed that she did believe it was her apartment, but they just didn't believe she was justified in shooting him. And that's what it all boiled down to. And it also seemed like that they, that's why they came to the decision in terms of the length of the sentence. If you were ballparking this, how long do you think it'll be before we'll hear from the justices on a ruling?
I would assume you're going to have to wait at least 6 months for an opinion. Wow, that's a pretty good amount of time, but actually not unusual.
It was interesting to me that Mr. Gladden, okay, so he went for about 8 minutes with no questions, and then the judges had a few questions, and then he talked for a few more minutes, and then he actually quit. He had 8 minutes left, and then Mr. Mola didn't come back and add anything. Does that surprise you?
Not really, Tanya. I mean, a lot of us appeal lawyers, we have only so many things we really need to say, and so we try to say them and then not take up the court's time with just taking the air out of the room. Years ago, when I was still a prosecutor in Fort Worth, a very good defense lawyer made his arguments. It was exactly the same as what he made in the brief. I had filed my brief. I was standing up to the podium and I said, unless the court has any questions, I have nothing to add to my brief and I'll stand on my brief. And so then he didn't do any rebuttal. And afterwards he told me, I've been doing this 30 years, Mike. I've never seen a prosecutor do that.
Well, and it seemed like I guess I was kind of surprised at how quickly the justices jumped in. I guess I have not watched a lot of these, so I don't know that I knew what to expect. Of course, I've covered a lot of trials, but appeals courts are just not something we really cover that much. And maybe that's something we should cover more of, but we just traditionally haven't. And so I wasn't actually sure exactly, it sounds to me like also that they're saying that mistake of fact and self-defense are just like, they're also in two parts of the penal code. So these two are not supposed to ever mix, basically.
That is their point of view so far. That's definitely the state's point of view. And I will give Mr. Mola credit in that I've never come across a case like this where someone goes into the wrong house believing it's their own place and shoots somebody else. So, it is truly unique in that regard. And in the briefs, both sides were kind of having a dispute over a case from Britain, which didn't involve anybody getting killed, but it involved property damage to one house where the person doing the damage thought they were going into another house where they had permission to go into anytime they wanted. Because that's just shows how far-flung this set of facts is.
I don't think I've been a crime reporter for, I hate to age myself, about 25 years. And no, this is not standard stuff. But I also think when the jury heard this case, they looked at the fact that she was a police officer. She had more training, a lot of training that average folks like us wouldn't have. And I think I think the prosecution made a pretty good argument that there was a reasonable expectation that she could have backed out or not entered. Because one of the things that was testified to during the trial was she made an affirmative decision to go ahead and enter that apartment. When she gets to that door, and of course there was an issue with the door not locking, but she makes an affirmative decision to go ahead and open that door and go in. And I think that was part of the thought process for the jurors when they made their decision. That she could have, there were other things she could have done. But I also want to say that I don't think we can ever lose sight of Botham Jean. After he died, I was one of the reporters. I was working that weekend, and it was a really rainy weekend, and I went and covered the prayer vigil that they had at his church. And what an amazing guy, amazing voice, Bible study leader. I met his mom, just wonderful people. And I do think that in all this, we have to remember man lost his life, and that it was a horrible thing that happened. And, you have to get beyond some of the legalism and the arguments and remember Botham Jean. Okay, so
let me
go ahead.
On that real quick, because I know some people who work in the criminal justice system, and please understand, I don't subscribe to this point of view, but they tried to argue with me that Officer Guyger shouldn't have even had to gone to trial. And I was just like, but Botham Jean was a person sitting in his own apartment.
Right.
How in the world can you say that you should even exempt? I can't maintain friendships with people who really adhere to that attitude.
Yeah, it was interesting. During the trial, I had a number of law enforcement officers reach out to me, and people that knew Amber Guyger. And, when they heard her testimony and they heard the entire trial, it changed some of their minds. I think a lot of the people I know ultimately understood and agreed with that trial, that jury. I mean, that jury had an unenviable, decisions that they had to make. But I think the thing that will always stick with me is we were live casting is when, you can't ever forget the hug. And Botham Jean's brother is, that will always stick with me. That is it doesn't change the fact that Amber Guyger has to pay for what happened. It was an amazing display of forgiveness that still stays with me to this day. I wish I could be like that, or I'm going to strive to be more like that. Okay, so one more question from Facebook. Somebody wants to know, what would her new sentence be if her conviction was overturned?
It would have to go back down to the trial court for another hearing. So we wouldn't know for a while.
So it'd be, and then again, as you said earlier, 3 to 6% of cases get overturned. So it's a really rare thing that occurs. It doesn't happen very often. And I would frankly be pretty surprised if it happened in this case. Is there anything else I should ask you? And then before I wrap up?
No, Tanya, I think, and I think y'all are doing a good service by showing this appellate process to a wider audience. Like I said at the start, a lot of people think that it's some kind of retrial, and it's just not. I mean, you're stuck with whatever facts were developed during that trial and are in that factual record, and that's what you have to argue from.
Absolutely. So if folks want to know more about the case, you can go to WFA/Botham Jean. That has all of our reporting. And you can also go back and watch the trial on our YouTube page. We covered every moment of this trial. And I agree. I think this was the first trial that we had ever done sort of court TV style play-by-play coverage. And I think that it had a lot of benefit. And we later on did it with another trial of a little girl that was murdered. And I know that we hope to do more trials in the future. With the pandemic, it has made it a little bit more difficult to do, as you can imagine, but we do definitely want to do more of these. Mike Casillas, thank you so much for joining us. I know that taking time out of your day to explain these, difficult legal issues, and we'll just wait to see what the court decides. Thank you so much.
Thank you for having me, Tanya.
Who was that woman? She was an idiot. Total idiot. She's like, oh, well, in all this, you have to remember the man died. That's not a defense attorney to remember. Sorry. Defense attorney doesn't have to remember jack shit. People are weird. Was that it? Did they take a break? What's going on? She really was an idiot. I guess that's it. Because the other channel ended it. Maybe not. Yeah, they ended it. Was it on break? Was it on break or it's over? Yeah, I just turned on my AC. It's hot here. It'll take about 6 months to find it. Oh, okay. I know, right, Rainey? J for J. Alright. So that's it. Now we wait. So what do you guys think? You think she's gonna get off? You don't think so? Yo, Iceland's getting killed with volcanoes. A volcano after volcano. I still say it's a damn loop. She got 10 years, yeah. I think this is a loop that they play over and over and over. I do. Watch how the volcano, watch how it goes up. I really do. I think it's a loop. 3,000 people are watching this right now. It never changes. Watch how it sparks up. It's the exact same spark up every time. I've studied this. Now it's going to go high. You see what I mean? It's the same pattern every time. All right, I'm going to look for that one. Where my cursor is where it went down. I have studied this. I just don't, I think it's a loop. If it lands by my cursor, it's a loop. Oh, so far not. That it's the same screen over and over and over. There it is. There's the one by the cursor. See, that's the same one they just had. Yet there's 3,000 people watching it. It does. It always looks exactly the same. Something's shaking. I know, right, Rainey? Like, I don't have 10,000 other things to do. Let's just watch a volcano. I don't know. That was a big one. I don't know. Maybe it's not a loop. Who knows? See, there you go, Andrea. 2,700 people watching this thing. They must all be stoned. I don't know if this is a different angle. I think it's the same one from a different angle. Do you realize how many people watch this stuff? Okay, this is a crane. And 2,300 people watching this thing. I'm in the wrong sector of YouTube. Where's Marissa? That's true too, Randy. Good point. Well, I'm going to go upside down. Why are they all hugging each other? 2 more days, I know. I'm not ready. Why are they all hugging?
Uh, 12. Gwyn.
Oh, that's right.
They're going to be gone for a year.
Houston copies.
No, they're coming back
That was
October
confirmation from Victor
2021.
Glover aboard the International Space Station. From the space station side, he is go for docking. The soft couch ring itself is fully extended. We're 115 meters in closing.
No, they're going to be gone for a year.
Looking at your screen, the port that we are going to be docking with is directly in the middle of the screen, that circular area on the International Space Station.
(5:10 a.m. Eastern Time). Hatch opening at 7:15 a.m.
Station Houston on 2 for Ike regarding SSC 17 and D2DM. We are seeing some strange configurations on the video, and we would like to close and restart that. We can take care of that from the ground if you would like.
Thanks, Andrea. It's not even done yet. It's only like half done.
Absolutely. If you're seeing nominal, that works.
They're coming back October of 2021.
Okay, so Victor Glover aboard the station still has...
And Dragon SpaceX soft capture ring extension is complete. Additionally, we did beat the sunlight for the Dragon Eye filters, so we are not going to command a hold.
Whoa, 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 whoa. You got stuck. You got
All right, so
stuck.
that's great news. We passed the 110-meter checkpoint that the ground operators were referencing, making sure the sun wasn't interfering with the optical sensors. The Dragon Eye.
Thank you, Andrea.
Part of the guidance and navigation and control system board Dragon.
Look at them selling merch.
Mark. We're good to go. We beat the sun there. So we're now inside 80 meters and closing. Dragon will pause at 20 meters. That's designated as waypoint.
All right, this is not that exciting for me. I mean, it's cool, but it's not like, let me stay online all day and watch it. Nope. How come they don't have Fluffer in space? How come they don't have you in space? Huh? You should be in space. Fluffer the space dog. Right? Fluffer the space dog. Fluffer the space dog. He just got all caught up in our wires. He got freaked out. But I saved you, right? I saved you. I saved you. Ugh. Ugh. All right, I'm gonna shut down. Do what I gotta do. I gotta take a shower. I gotta get ready. I will see you guys later. Whoa, whoa, whoa! They caught my necklace. You're just getting caught in everything, Fluff. You're just getting caught in everything. All right. I will see you guys later. Have a wonderful day. And that's it. I will not be around much. Tonight, I got shit I got to do, so I don't think I'll be back tonight. All right. I will see you guys tomorrow. And that's it. Have a good day.